皆様こんにちは。ベーカーのマッケンジー法律事務所パートナーのMasumotoです。本日は前回に引き続き国際仲裁ビデオシリーズ東京ミーツ香港と題しまして、弊所香港オフィスパートナーのPhilippハヌシュ弁護士をスピーカーに迎えてお届けいたします。
Philipp, thanks so much again for your time and for joining us for this second part of our series. We wondered if you could let us know about any current trends or news in disputes in Hong Kong or otherwise.
Well, obviously, Hong Kong is a very busy seat, so there's always a lot going on, right? And 2025 was quite a busy year for the courts in lending their support to arbitrations, I should mention. But perhaps I'm going to focus on 3 points. First, a review of the arbitration ordinance has recently been initiated. As you can imagine, successful arbitration hubs always look for ways to improve their offering to meet user needs and expectations. So a working group has been established and tasked to identify updates to strengthen Hong Kong's position as a leading international arbitration hub. And some aspects under consideration include the determination of the law of the arbitration agreement, the scope of disputes for arbitration, the court's powers in support of arbitration, and of course the use of AI in arbitration, a very hot topic not only in Hong Kong but of course around the globe. Second, I want to give a quick word on the HKIC rules, which are widely recognized as market-leading arbitration rules, and they're very popular with parties in Asia who choose to arbitrate in Hong Kong. So the HKIC rules were last revised in June 2024, and a key theme of the revisions was to enhance time and cost efficiency. But no drastic changes were introduced because users were already highly satisfied with the previous set of rules, the 2018 rules. But the HKIC recently made an adjustment to its expedited procedure under the HKIC rules. So that's a procedure where the tribunal can decide disputes on a document-only basis if that's appropriate, and it must make its award within 6 months of receiving the file. So effective from 1st of January 2026, a party can apply for the arbitration to be conducted under the expedited procedure if the sum in dispute doesn't exceed approximately $6.4 million. That's a significant increase from the previous limit of $3.2 million, so it doubled actually. And that means that going forward we will see a lot more cases under the expedited procedure, which users keep indicating is something they consider one of the most efficient tools in arbitration. And the third point I want to make is that Hong Kong arbitration, especially HKIC arbitration in Hong Kong, has become the preferred choice for disputes with Russian parties, because Hong Kong has no Russia sanctions. And a sanctions-neutral seat is quite essential because arbitrating with a Russian party, that can present significant complexities and risks. For example, cases frequently end up in the Russian courts because cases or seats chosen might not be considered sanctions neutral. That's something to bear in mind for Japanese parties when they have transactions with Russian parties.
Thanks so much for that insight, Philipp. So moving on, do you have any practical tips or advice for Japanese companies when they're negotiating contracts with counterparties in Hong Kong?
Sure, and being a dispute resolution expert, I probably want to focus on 2 important points which I think should always come up and be addressed in negotiations of cross-border contracts. That's the governing law of the contract and the arbitration clause. So first of all, I think the contract should always expressly designate its governing law, and that law might not be the same as the law of the chosen dispute resolution forum. So it could be Japanese law governing the contract, but arbitration in Hong Kong. Hong Kong law, as an example, is a popular choice for commercial transactions because it's reliable and predictable. And it's also often chosen as a compromise by parties from different jurisdictions. So perhaps 2 tips where Hong Kong law is chosen. First of all, Japanese parties should bear in mind that legal concepts under Hong Kong law may differ significantly from Japanese law. So let me give you an example. Hong Kong law doesn't recognize the general concept of good faith. and parties also don't have any general duty to negotiate in good faith. And secondly, Japanese parties should expect detailed and comprehensive contracts. Why is that? That's because Hong Kong law has very few statutory duties, and implied duties are also limited. So the parties would usually regulate all important matters expressly in the contract, rather than relying on substantive law principles to fill in the gaps. But I think whatever law is chosen, Japanese parties should of course ensure that their position under the contract is well protected. And the second point I want to make is strategic planning and risk management. That's really key in a contract. And it's important to bear in mind that this also applies to dispute management. And one of the most effective tools for managing disputes in a cross-border contract is of course a well-drafted and effective arbitration clause. And that can be possibly in the form of an escalation clause with negotiations as a precursor to arbitration. So Japanese parties should really ensure that they make informed arbitration choices when actually agreeing on arbitration. Give you an example. I've mentioned that in the first session, right? Hong Kong arbitration should actually be a preferred choice for transactions with mainland Chinese parties because it can offer Japanese parties specific unique advantages. So in a nutshell, Japanese parties should really involve lawyers who are familiar with the type of contract, the governing law of the contract, the dispute resolution mechanism, and ideally also, of course, with the parties' cultural backgrounds. And at Baker McKenzie, as you know, we are, of course, well placed to help Japanese clients negotiating contracts with its Chinese parties or other foreign parties.
Brilliant, thanks, Philipp. And likewise, certainly agreed. We can help clients wherever they're having problems. So the next question really is whether you have any practical tips for or advice for Japanese companies when it comes to Hong Kong's dispute resolution system.
Sure. So as I've probably indicated in the first part, Hong Kong is widely recognized as a reliable, neutral and business-friendly dispute resolution hub. But as with every place, it's important to understand the local legal system and especially also the dispute resolution system. So probably say a bit more about the latter. I think Japanese parties should bear in mind that Hong Kong, like Singapore, is a common law jurisdiction. And as such, it adopts an adversarial dispute resolution process. And this means that the arbitration process is largely driven by the parties and not so much by the arbitrators. And so there might be various characteristics with which Japanese parties may not be familiar, because Japanese parties come from a civil law system and that's more used to an inquisitorial approach. So I want to focus perhaps on two areas. First of all, I think Japanese parties should be aware of the so-called without prejudice rule. That rule means that written or oral statements you make in a genuine attempt to settle a dispute must not be put before the tribunal as evidence of admissions against you. So obviously the rule intends to encourage settlement, right? Parties are more likely to settle if they can speak freely and they know what they say won't be used against them. And the second point I want to explore more is a specific characteristic of the adversarial system, and that's actually document production. So that means that parties are usually required to produce relevant and material documents in an arbitration. And that's in addition to those documents who they want to rely on anyway. While that's actually quite common in international arbitration generally, it still can catch Japanese parties by surprise. So when arbitrating in Hong Kong, Japanese parties should bear in mind that they may have to produce, for example, internal documents or documents that are detrimental to their own case. There are, of course, exceptions to document production, and one of those is an important one that concerns legal professional privilege. Privilege is a substantive legal right of the client that protects the confidentiality of certain types of communications. And that can be either legal advice privilege, so that's communications created either for the dominant purpose of seeking or for giving legal advice, or that can be in the form of litigation privilege. That's communications made for the use of or in connection with actual, pending or contemplated litigation. I think it's important for Japanese parties to be at least aware of the concept of privilege because, as far as I understand, Japan has no equivalent attorney-client privilege that's equivalent to the common law privilege. But whether privilege can apply is often a very complex question, right? So my overall tip would be for Japanese parties to bring in a suitable disputes expert early, because that will ensure that communications are, to the extent possible, protected by privilege, which may otherwise not be the case. And it also ensures actually that a proper paper trail is established, and that can then either support the client's case or it undermines the other side's case. So really in both instances I've addressed on dispute management, right? That's at the contract negotiation stage, which I've discussed earlier, but also when a dispute has arisen. I think it's really important to involve disputes lawyers early, and that clients and Japanese clients treat this early involvement more as an investment in dispute management rather than an expense. And that actually can help a lot to avoid, or if not to avoid, to manage disputes properly.
Totally agreed on that, Philip. It's interesting. I think early engagement's often not the easiest thing for in-house counsel to get their company to buy into. But from my experience and our experience, getting that early engagement is usually the way to get to a quicker resolution or to avoid a formal dispute in its entirety. Thanks so much for your time today, Philip. Some really, really great insights from you on Hong Kong, and we look forward to continuing to work with you in the future.
Thanks a lot for the invitation, Dom. I hope it was useful, and I hope we see more Japanese parties coming to arbitrate in Hong Kong.
Thanks, Philip.
それでは私から簡単に日本語でご説明させていただきます。まず、香港における昨今の動向についてですが、香港は仲裁のハブとして、仲裁の完全性と公平性を保護しつつ、仲裁に要する時間とコストを効率的にし、利用しやすいものにするため、常に仲裁制度の改善を図っているということですけれども、昨今、仲裁条例の見直しが検討されており、作業部会を立ち上げ、香港が主要な国際仲裁のハブとしての地位を強化するためのアップデートを特定する作業を行っているということです。検討中の主な項目としましては、仲裁合意の準拠法の決定、仲裁対象となる紛争の範囲、仲裁を支援する裁判所の権限、また仲裁における AI の活用があるということでございます。また HKIAC 規則は直近では2024年6月1日に要する時間とコストの効率性向上の観点から改正を行っていますけれども、最近また改正がなされまして、書類のみで仲裁庭が判断し、事件記録受理後6ヶ月以内に判断を下さなければならないという迅速手続き、Expedited Procedure に関し、当事者が申し立てることができる案件の紛争金額が、従前の約320万 USD から約640万 USD に引き上げられたということです。当該金額を超えない案件の場合には、当事者は迅速手続きを申し立てることができることとなりました。この改正は2026年1月1日から実施されています。これにより迅速手続きの案件が大幅に増加する見込みがあるということです。最後に香港はロシアに対する制裁を実施していませんので、ロシア当事者との間の紛争解決地として好まれているということです。ロシア当事者との仲裁は複雑で、ロシア国内での訴訟手続きに至る可能性もありますので、制裁に中立的な仲裁地を選択することが不可欠であるということでした。次に、香港において相手方企業と契約交渉を行う日本企業への実践的な助言という点ですが、準拠法と紛争解決方法に関する交渉が重要であり、契約書では準拠法を明示的に指定すべきであるということです。なお、香港法が準拠法として選択された場合、香港法における法的概念が日本法と異なる点がある場合に、異なる点がある点に注意が必要であるということです。 例えば香港法はグッドフェイスの一般的な概念を認めず、グッドフェイスで交渉する一般的な義務は存在しないということです。また契約は詳細かつ包括的に規定され、法律に基づく義務は少なく、暗黙の義務も限定的であるということです。よって当事者は契約において全ての重要事項を規定し、契約に曖昧さを残すべきではないということでした。契約書のドラフトにおいては、立場が十分に保護されていることを確保する必要があるということです。また、紛争が起こった場合のメカニズムを定めることが重要であり、仲裁を紛争解決方法とする場合には、適切で効果的な仲裁条項を定める必要があるということです。この場合、仲裁に先立って、まずは当事者間で交渉を行うというようなことも可能となります。また、十分な情報に基づき仲裁地の選択を行う必要があり、特に中国本土の当事者との取引には、香港を仲裁地とする仲裁を優先的に選択すべきであるということです。契約書作成の際には、文化的背景にも精通している弁護士に依頼することが望ましく、弊社香港オフィスは中国やその他の外国企業との契約交渉において、日本企業の皆様をサポートさせていただいているということでございました。最後に、香港の紛争解決システムに関する日本企業に対する実践的なアドバイスですけれども、香港は信頼性が高く中立的でビジネスに優しい紛争解決のハブではありますが、香港はコモンローを採用しており、当事者を中心とした敵対的な紛争解決プロセスとなっている点、注意が必要ということです。まず、Without Prejudiceルールを認識する必要があるということでした。このルールは和解交渉の過程でなされた発言は、仲裁点に対し自白の証拠として提出できないというものとなります。次に、内部文書や不利益な証拠も含めて、関連性のある重要な文書を相手方に開示する文書開示の手続きがあります。国際仲裁では一般的ではありますが、日本企業にとってはあまり馴染みのない手続きとなります。このような文書開示の手続きには、弁護士依頼者間秘匿特権といった例外があり、一定の文書については相手方に対する開示から保護されます。このような特権の利用や判断には専門的な知識と判断が必要となりますので、早い段階から弁護士を関与させることが重要であるということでございました。以上、前回から2回にわたりまして、弊社香港オフィスの弁護士をスピーカーに迎え、香港の仲裁実務の概要をお届けさせていただきました。引き続き本ビデオシリーズをご覧いただけますと幸いです。本日はご視聴いただきましてありがとうございました。